Good afternoon, everyone. This is Linda Nash. I'm here with my colleague, Per Oscarsson from Beresford Booth Law. And we're here today to talk about estate planning for unmarried couples, and specifically for married couples that under Washington law may be determined to be in a committed intimate relationship. This is a court-created doctrine, meaning there's no statute in Washington that applies to this. It's somewhat akin to what used to be known as common law marriage, but it doesn't have the same exact factors resulting in it. There's a three-prong approach that courts take to determine if a claim for assets within a committed intimate relationship, or sometimes you'll hear us say CIR. There's a three-prong test, and the first one is probably the most important. Does a committed intimate relationship exist? There's 5 factors that the courts have laid out. They're not exclusive. Weight is not given equally to all of them. It really depends on the specific case. And we'll just run through them sort of quickly and give you an overview so you can see how that affects your estate planning. They are continuity of cohabitation, duration of the relationship, purpose of the relationship, pooling of resources, and intent of the parties. So continuity of cohabitation and duration of the relationship kind of go hand in hand. I have seen a case where a committed intimate relationship was established after just 4 years. And we've also seen cases where you don't have to actually have cohabitated for the entire time, but for a significant amount of time. And Per is going to talk about a couple of the other factors where the court determines whether a committed intimate relationship it exists.
So one of those is the purpose of the relationship. And of course, there can be any number of purposes for having the committed intimate relationship. And then the pooling of resources, and another kind of a corollary on the pooling of resources, as I have seen, has also been services for joint projects. Now, that could be projects that are personal to the couple, or it could involve even like a business to be run by both. And then the intent of the parties is also looked at. And as Linda said, the weight will vary from case to case as to which factor may hold the greatest sway or influence. And it's going to be up to the court to determine, because they have the discretion to look at all of those. And each case is supposed to be looked at on its facts. So you look at all 5 of those, and as Linda said, it's not an exclusive list. So there may be some things that we haven't mentioned that a court could also look at. And it's entirely possible that no court has ever really been asked to look at that factor before. But certainly these 5 are the ones that really, I think, probably focus the court's attention more. But that's not to say that there couldn't be other factors that could help, depending upon the party, either determining yes, there was a committed or is a committed intimate relationship, or no, there wasn't or isn't.
The courts have used this phrase regarding what a committed intimate relationship is. It's a stable marital-like relationship where both parties cohabitate with the knowledge that a lawful marriage doesn't exist between them. And normally this comes up in the context of what happens when 2 people are in a committed relationship and they split up. How do we divide our assets, whether it's been 4 years or 40 years? We have a lot of great articles on our website that goes into specifics about the factors that go into a committed intimate relationship and how they could affect you. What we want to talk today about is how does your estate planning tie in with being in a committed intimate relationship. The first step is to determine if you are, and that's what we just covered. But there's some things that if you realize you're in that type of relationship, but you probably need to take a look at your estate planning, or in the absence of estate planning, what potentially could happen, what issues could come up. And Pear's going to talk about a couple that are pretty important.
So the first one I think of is powers of attorney, because there are statutes that allow a spouse, for example, even if there's no formal power of attorney document, a spouse would have a right to take action on behalf of the other spouse under appropriate circumstances. That probably is not going to hold true in a committed intimate relationship, even though that relationship may be as strong as in a marriage. And so having a power of attorney that grants one of the partners the authority to act on behalf of the other partner, whether it be for financial matters or healthcare matters, can be very important, because absent that, there may not be any authority to act on behalf of a partner who is, for whatever reason, incapable of acting on their own behalf, whether it be something like they've been in a car accident, for example, and they're unconscious, and there's no one else that can speak for them. Or it may be a health-related matter that has rendered them incapacitated in some way, that they can't make decisions, whether they be healthcare decisions or financial decisions, on their own behalf. So having a power of attorney, particularly a durable power of attorney that is not affected by a disability or incapacity, can be very important. And just as important as if the two people might be very good friends and not in a committed intimate relationship, but granting the power to that one person to act on behalf of the other. So focusing on that, I think it's very important to make sure that you've got that authority to act. And of course, that is a decision to be made by the person granting it, because there's certainly nothing that says that they have to grant the power of attorney, but it may be in their best interests to do so, because there may not be anybody who could otherwise act on their behalf.
Of course, we, as estate planning attorneys, would recommend that everybody have a durable power of attorney,
Yes.
even if you are married. But I think it's especially important if you are not married and you're in a relationship where you would want your partner to be the person to come in and make these decisions for you. It could even go so far as, can my partner visit me in the hospital?
Sure.
Would somebody else be able to exert their statutory authority to keep my partner from coming to visit me? So a lot of good reasons to have a durable power of attorney for both healthcare and finances. It's always a good idea to have that, but especially if you're in this type of relationship. The next thing to consider would be adding your partner to your will. Partners in a committed intimate relationship setting don't have the same rights that a spouse would when one partner passes away. So if you don't have a will, there's no intestate rights of the surviving partner. And the statute's going to decide where the deceased partner's assets go, which may or may not be where the deceased partner wants. So if you come up by preparing a will, you can outline specifically whether you want your partner to receive anything under your estate. Maybe you don't. Maybe you want to divide it between your children or with other relatives. But by having a will, you identify this person and you leave them specifically whatever assets you want. And there's other ways you can take care your partner on death that Pear's going to talk about.
Yeah, so one of those would be like payable on death, a bank account, or a transfer on death securities account. Those can be done whether or not the granting person is in a committed intimate relationship. But again, for the same reasons that apply to wills and lack of a will upon death, having the CIR partner named as a beneficiary under accounts such as those is one way to make sure that the property goes the way that the holder of the property would like it to go. Again, even in those circumstances, there is no guaranteed right of the surviving partner to receive any of it. That can be true for life insurance policies the same way. A transfer on death deed is another option where even the existence of the CIR isn't even necessary to be described in the deed. It can be, but it certainly is not required to be. One of the things that I think is important to keep in mind, particularly if you don't do any of those things, and we have to go to the intestacy statutes, those that apply when there is no will, and the fact that under the intestacy statutes, when there is a married couple, they look at what is the community property and what is the separate property of the spouses. And the law states what percentage of community property, in this case, all of the community property of one spouse would go to the other. But if there's separate property, the proportion of separate property that goes to the surviving spouse differs depending upon who the other potential heirs are. If it's children, the surviving spouse gets a 50% and the children get a 50% interest. But if the other heirs are someone other than a spouse, then the spouse gets 75% and the other heirs share 25%. Those statutes don't apply in a committed intimate relationship, and the court will look at an equitable distribution. And equity could mean, I should go back. Even if property is titled in the name of one of the two partners, if they acquired it while they were in a committed intimate relationship, that will be included in the assets to be distributed, and the surviving partner will have an interest in it, whether or not their name is on the title. And that could be real estate, it could be vehicles, anything that might even have a certificate of title, because the courts will look at income and assets acquired during the time of the committed intimate relationship to determine what actually is before the court. Because if there are assets that the deceased partner had that were acquired prior to the committed intimate relationship, those may not be before the court and most likely won't be before the court. I've kind of gone a little past what Linda had mentioned about some of the planning that you can do during lifetime, but it's pretty much the same kind of planning that you would do whether or not you were in a committed intimate relationship or whether or not you were married. The only way to really have some control over where do your assets get distributed, to whom do they get distributed upon your death. And unfortunately, the surviving partner in a committed intimate relationship does not have the protections that are available for a surviving spouse in a marriage.
Right, unless you undertake that estate planning. And
Right.
I think an important thing to think about too is I think a lot of people who've been in these relationships for many years, but perhaps maybe their assets are all titled in their own names, and they make an assumption that upon my death, this asset is all mine and I have the right to give it to my kids or my brothers or my parents, when in fact that may not be the case. And so your estate may not be distributed the way that you think it's going to be distributed. So estate planning is important for all kinds of people, single people, married people, and people in a relationship like this. There is, you could consult with a family law attorney if you wanted to enter into some sort of formal agreement. Maybe you're thinking, hey, I think I am in a relationship and this is not how I want things to turn out. You and your partner can each consult with a family law attorney, and you can perhaps come up with an agreement as to how your property is going to be divided in the event of a separation or the death of one party. That is a very in-depth analysis of the relationship and the assets. And it's a little in-depth for this topic here, but I would definitely consider consulting a family law attorney. Of course, we have a lot of excellent ones here at Beresford Booth, but it's just a recommendation. Anything further, Per?
I don't think I had anything further. Just, I think the big watchword is plan.
Plan ahead, regardless of the type of relationship you're in or that you think you're in.
That's right.
Great seeing everybody, and we will be back next month with a new topic.
Thank you.
Thank you.